Good morning and welcome to Employment Hour in 30, telling you about the employment rights you didn't even know you had. I'm John Scholes, your host, along co-host here, Lior Samfiru from the Samfiru Tumarkin law firm. And anytime you want to contact, simple, employmenthourtv.ca or help at employmenthour.com. That is email, and 1-855-821-5900. We'll get to phone calls later today. We'll get to the severance pay calculator, Lior, but we always start with a little segment we call the week that was. How was it?
Well, John, it's been a very busy week. A lot of people that saw our show in previous weeks have been calling, asking questions about their legal rights, about their employment law situations, which is terrific. This is exactly why you and I are here right now, to educate and inform people about what they need to know if they have a job, if they lost their job, maybe they're being mistreated, or there's a problem, something's happened, their boss did something. What does that mean? Can they do anything about it? So we're going to talk about all these things this week, every week. And to get us warmed up and started, let me tell you about a situation that came across my desk over the past few days. Again, this is a listener of or a viewer, I should say, of our TV show here. This gentleman had worked for a company as a machine operator for some 30 years. He's an older gentleman in his mid-60s. I think he's 66 years old. And his employer came to him a few months ago and essentially encouraged him to retire. The employer said, well, you know, you're getting older. Wouldn't you want to spend more time with your family? Maybe it's time to slow down. You've been working hard all these years. Well, unfortunately for this gentleman, from a financial standpoint, he's not able to retire. He had no intention to retire. And he told his employer that, no, I'm good. I'm not retiring. I'm going to continue working for the foreseeable future. He actually felt that the employer was very much taken aback by this, very surprised to hear him say that. Well, guess what, John? Wouldn't you know it? Starting at that point and moving forward, all of a sudden, nothing that he could do was right. Pariah. Yeah, he's a pariah. He can't do anything right. He gets warned. He gets disciplined. He even got a suspension. Everything he did resulted in criticism and problems. And again, this is a 30-year employee. Presumably, he knew what he was doing. Well, fast forward a few weeks ago, he gets terminated. The company says, given all these issues we've had with you, we're going to let you go for cause. We're not going to pay you any severance. That's when he called me after he saw our show, and he was very upset. He was distraught. 30 years, John, and he wanted to know what his entitlements were. Well, here's the thing, John. It's clear what's happened here. The company wanted him to retire. They thought that maybe he's too old. And when he wouldn't retire, they decided to make the decision for him, to build up a case so that they have an excuse to get rid of him. What they were trying to do, John, is avoid paying him his severance. For him, probably about 2 years' pay. They didn't want to pay that, so they thought, well, maybe if we can show that he's not a good employee, we can avoid paying that. Well, that's so clear that it's what they did, and that also makes it a human rights matter, John. They clearly did this because of his age, because they felt he was too old. So not only now are we going to be pursuing this as a wrongful dismissal to get his 2 years' pay, but also as a human rights issue. And I want our listeners and our viewers to remember this, that your employer can't come up with reasons to discipline you and then to fire you if they're not legitimate. If they're not legitimate, they're not valid. You cannot be fired for something you didn't do or for something that you've been doing all along. If that's what happens to you, that's a wrongful dismissal. You have to get some advice. You have to give me a call.
For someone in that situation, whether they be of this gentleman's age or otherwise, what's the if this is happening, what steps do you take while it's happening before they decide to let you go? What can you do?
You know, this gentleman, really all he wanted to do is get his job done and do his work properly. What I would have told him had he contacted me when the discipline started is document things. Right. Keep records of what actually happened. If they say you did something wrong and you didn't do it, respond. Put that in writing. Say, you said that I did this, but I didn't do it. Here's what actually happened. The problem with accepting discipline and not doing anything about it, that you're almost being seen as agreeing to it, and you don't want to agree to anything that shouldn't be agreed to. That said, this matter, John, was so obvious what the company was doing, trying to avoid paying him his 2-year severance and mistreating him based on his age, that I have no doubt we'll be able to resolve it on really good terms.
Online, it's employmenthourtv.ca or help at employmenthour.com through email. Phone calls as well, 1-855-821-5900. Got a call now from Darren, so we'll have a listen to it.
I was an operations supervisor, and I was let go about a month ago from my employer. I never missed any time. Everything was great. But then this year I did miss some time. The last time I missed a day, and they asked me what was going on, and then I kind of told them, you know, it's financial issues. The next time I missed a day, I was in a car accident. I sent in the information that I was in a car accident, and they fired me that night. They didn't give me any termination pay or severance or nothing. So I'm just not sure if, you know, do I have any recourse?
Sure he does. What does he do?
Well, John, so as I understand it, he missed 2 days of work and then he was fired without any notice, any compensation. So the question is missing 2 days of work legitimate grounds for cause? It's not even close, John. Let's look at it from the company's best case scenario, that he missed 2 days that he should not have missed. That's not cause. It's not even close to being cause. Let's remember that cause is the worst penalty for the worst offenders. So if you've missed a lot of work and the company's tried to discipline you and you still don't get it and you don't care, well, maybe at some point the company may have cause. But if you've missed 2 days, no, that's pulling the trigger before the company should. That's a wrongful dismissal. Now, beyond this, if he was in a car accident, well, guess what? That's actually a legitimate absence.
Right.
It's not even cause for any form of discipline. So he's been wrongfully dismissed. I encourage him very strongly to give me a call. Let's talk about that. And for any of our viewers, if your employer lets you go supposedly for cause, in other words, they say you've done something bad, something wrong, so they're not going to pay you severance. In most cases, that's not cause. In most cases, the employer pulls the trigger before it should, and you're owed full severance. So it's so important, John, to get legal advice.
What does he tell his employer even before he's made that phone call to you?
Well, what he has to tell his employer is, first of all, he wants to make it clear to the employer why he missed work and that he missed work for legitimate reasons. And I would always try to say, well, why are you doing this for me? Why are you punishing me? Is there what behavior are you trying to correct? You're trying to prevent me from getting into a car accident in the future? Clearly that's not the case. So he really should, this employer really should have known better. Probably, again, another situation of an employer trying to avoid paying severance by latching on to something fairly minor.
1-855-821-5900, that number anytime to get a hold of Lior or anybody on his team as well. Terminationquestions.com as well. This is a good one. This is where you can leave a question, just type it in, and Lior or someone else from your firm will get to it. So you can leave those at terminationquestions.com. We got one here, says, I've been laid off because of a work shortage, but have not been given a clear idea when I can return to work. Can my employer do that? And what if they have no intention of bringing me back?
Well, John, you're going to know what I'm about to say because we've talked about these issues before, but many of our listeners right now are going to be dropping their remote control in shock. And that is that a temporary layoff, as our gentleman there had described, is actually illegal.
Right.
An employer does not have a right to lay you off temporarily. And many people are going to be very surprised by that. But no, that is the law. So in other words, if you've been laid off temporarily, you have an option. You can accept the layoff and wait and hope the company calls you back, or you can treat your employment as being terminated as of that moment and require the company to pay you your full severance. An employer does not have a right to lay you off temporarily. They can't say, well, we're going to lay you off for 6 weeks, 10 weeks, 12 weeks. There's a lot of confusion about this topic, so I want our viewers to understand that you can't be laid off temporarily. So for this gentleman, regardless of what the intention of the company is, whether they want to call him back, whether they don't want to call him back, he right now can treat that as a termination and get severance. And if you've ever been laid off temporarily, you don't just have to wait it out. You don't just have to wait at home without compensation. You may be better off to treat that as a termination, get your severance, and move on to a different job.
What are the repercussions if you allow them to do it once, maybe twice, even 3 times? What goes on?
I knew you'd ask me that.
You bet.
So the problem, John, so I just said that you can't lay off someone temporarily. Well, what happens if you let the company do it? You were the good soldier, they laid you off temporarily, you came back. Well, the problem with doing it is now you've given them the right to do it again and again and again. So all of a sudden, now you can be laid off temporarily all the time. What kind of a job is that really? You're going to be off now for 2 months. You come back a few months later, you're going to be off for 6 months. That's not a way to live. That's not a way to work. So that's the problem with temporary layoff. So I say if your employer is going to start laying you off temporarily, you may be better off to treat that as a termination. That said, John, and this is very important, I don't want anyone to just quit or treat it as a termination without speaking to me first. First, we need to talk about it, and then we can decide how to best pursue it.
There's some times where it's kind of understood. If you're in roofing or if
Right.
you're in pool maintenance or gardening, it's implied that you're going to be laid off for half the year possibly, right? That's different.
That is very different. Some jobs, by their very nature, yes, you can be laid off because there's an off season. So you mentioned roofers, for example, pool cleaners. Well, there's not a lot of pools to clean in the winter. There's not a lot of roofs to build in the winter. So yes, it's assumed that you're going to be laid off during the off season. But if you're working in a factory, you're working in an office, you're working somewhere where there's no regular or obvious off season, you cannot be laid off temporarily unless, of course, you did it before or the company did it before and you let them do it. A temporary layoff is a termination.
Emails, help@employmenthour.com. You can use that anytime. Write to Lior, a member of his staff as well. Daryl says, I was let go a few months ago after 14 years as a manager at an IT company. They offered me 8 weeks pay and severance, but said my offer was only good for 24 hours. After 24 hours, they said it would drop down to 4 weeks severance, so I signed right away. I think I was probably owed more.
My gosh, he was definitely owed more, John. Probably looking at a year's pay that he was owed, not 8 weeks, certainly not 4 weeks. And the problem always with the deadline like that is you feel the pressure, you feel the stress, you feel, wait a second, if I don't sign the severance offer by the deadline, I'm going to lose something. Well, I've said this before, I'm going to say it again. That deadline means nothing. Your legal rights don't expire Friday at 5, Tuesday at 3, or any other date. In fact, you have 2 years to pursue your entitlements. That deadline is a pressure tactic, John. It's all it is. Now, in this particular situation, normally I would say, well, he's out of luck because he signed off on the severance offer. But if he only received 4 weeks pay after 14 years of service, that would be a breach of the Employment Standards Act. In other words, that would be actually illegal even if he signed it. So we actually may be able to get him out of it and get him his full severance. Now, that's not something I want our viewers to do. I don't want you to sign a severance offer and then say, now let's get out of it. 99% of the time you can't do that. The best advice is, regardless of that deadline, you get advice, you give me a call. You don't like me, speak to another employment lawyer, but you do not accept your severance offer until you've had proper advice. You don't want to find out that you're owed another year's pay. Another year's pay. Can you imagine?
Yeah.
And then you said, no thanks, I'm not going to take it. That's a horrible situation to be in.
So what does someone do? I mean, they're in that office, they've got HR there, there are 4 or 5 people in front of them, they got this offer. I mean, they're nervous, they're excited, not in a good way. What do you tell them to tell the employer?
Well, first of all, what I tell the employer is, I'm going to take some time to consider it. And I don't think an employee should try to understand on the spot what their severance offer is. I think they should take their paper and their envelope and leave and get their belongings, not make a scene, go home, take it out of the envelope, read it again and read it again, understand it, give me a call. Probably the less said in a termination meeting, the better. They can't lock you in an office to make you sign. No employer would ever do that. Leave there. Get advice. As long as that takes, that's fine, even if it's beyond the deadline that the company gave you.
Their next fear, of course, is going to be that, you know, if I don't take this offer and I go back after talking to you, they're going to offer me less.
Right.
Do that.
No, they can't. The law is the law. So if you're owed 10 months pay, you're going to get 10 months pay. They can't say, well, we only want to pay you 3. Well, it's very nice that you only want to pay 3. The law says you should pay 10. So you should never have to worry about losing your severance offer. Okay? That's not going to be the case. If you're owed more, then you're going to get paid more. If you're not owed more, I'll tell you, you're not owed more, you should accept it. 90% of the time, over 90% of the time, John, when I look at a severance offer, it's completely inadequate. It's not even close to being adequate, and that's why we're here. That's why we're doing this show.
EmploymentHourTV.ca, help@employmenthour.com, and the phone number 1-855-821-5900. Anytime you want to get a hold of Lior. We'll take a short break. When we come back, we'll talk about being fired while you're pregnant, and we'll get into the severance pay calculator as well. Lost your job? Employment law myth number 7.
Involving an employment lawyer is expensive.
Fact, in most cases, fees are nominal, and the employer will ultimately cover the fees. Always go to employmentlawyer.ca and check with the employment lawyer first. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 9.
I can just call the labor board instead of a lawyer.
Fact, the labor board cannot help an employee get their full entitlements. Always go to employmentlawyer.ca and check with the employment lawyer first. More Employment Hour in 30 here. We'll get to your phone calls, 1-855-821-5900. Got a call now from Cindy. We'll have a listen to that.
I'm currently pregnant. I work at 3 different stores, and one of the stores, he's kind of giving me a hard time. It seems like he's trying to find a reason to get rid of me, and he's always evaluating me, checking my work. So I kind of feel stressed out, and I just feel like he's about to let me go, and I wanted to know if I would be entitled to any compensation if he does fire me.
We talked about this last week. Don't mess with mama.
You know, and it's a shame that we actually have to keep talking about it because these issues come up. And I've seen this before many times, John, where a woman tells the employer that she's pregnant, she's going to take a maternity leave, and everything changes beyond that point. All of a sudden, she's not doing a good job. All of a sudden, she's being disciplined. She's being treated differently. And the only thing that's changed is that she is pregnant. Well, guess what? That's just wrong. That's illegal. Forget about wrong. It's actually illegal. You cannot mistreat someone. You cannot discipline someone because they're pregnant or because they're going to take a mat leave. You certainly cannot, under any circumstances, fire someone because they're going to take a mat leave. That's illegal. That's a violation of the Human Rights Code. It's a violation of the Employment Standards Act. And as obvious as that is, and it really is obvious, I still get calls, emails, voicemails like that every single day, sometimes several times a day. So my advice here is this. She hasn't been fired yet. She thinks that they're working her way towards that. So start documenting. Send emails confirming what's happened. If your boss did something or said something to you, send them an email confirming, here's what happened today during lunch or during our meeting. Have a diary or a journal where you keep track of things that happen as they happen. And, you know, God help the company if they decide to let you go. The law's going to come down pretty hard on them. It's illegal. Not only would you be, of course, entitled to severance, there's human rights damages there. There's also what we call reprisal damages. So for all our viewers, if your employer lets you go because you're on mat leave, going to take a mat leave, coming back from a mat leave, or any parental leave, that's illegal. You really shouldn't have to take that. That's not something that's acceptable. You get advice and we resolve it.
Beyond this show, of course, every Saturday morning and our weekly radio shows as well, you want to find out exactly what your severance offer should be. It's really simple beyond talking to you or anybody on your team. SeverancePayCalculator.com. We love this tool. It's been around for almost 5 years now. Tell us how it works.
So, John, you and I have started our radio show several years ago, and we started that because I identified that there's so many misconceptions out there when it comes to termination of employment and employment law in general. And I wanted people to stop believing things that are not true and to give people access to the right information. So we get on the radio several times a week. We get here on Global TV and we talk about employment law. But I wanted to make it even easier for people to find out exactly what they're owed if they lost their job. So I created the Severance Calculator. It's available online at severancepaycalculator.com. And what the Severance Calculator does, as the name suggests, is it tells you, it calculates how much compensation, how much severance you're owed if you lost your job. Doesn't matter if you're old, young, senior, junior. It's free to use. It's anonymous. You answer 3 simple questions. It takes seconds, and you find out how much you're owed. Maybe you haven't lost your job. Maybe you're worried about losing your job. Maybe neither of those is true, but you're curious. You're interested to know, what would I be owed if ever they let me go? SeverancePayCalculator.com is the address. Use it. Make it the first place to go to if you lost your job. And if you know someone that lost their job, your friend across the hall, your family member, the place to go to is SeverancePayCalculator.com. And John, I wanted to give an example.
Yeah, for sure.
Someone gave us a submission recently on the Severance Calculator. You have the option to contact me if you want from the Severance Calculator. So this gentleman had plugged in that he had worked there for 16 years, 58 years old, as an admin assistant at a salary of $45,000. And this person was offered 3 months severance. Well, the information was input into the Severance Calculator, and the Severance Calculator correctly stated that in that situation, the person would be owed between 16 to 18 months pay. Again, they were offered 3 months. So the difference here was somewhere over $60,000. And I'm not bringing this example because it's unusual. In fact, I'm bringing this example because it's not unusual. I deal with exactly these scenarios every day. And this person, because they went to SeverancePayCalculator.com, were able to find out how much they're owed, knew that their 3-month severance offer was completely inadequate. And on that basis, I was able to help them make sure that they get what they're owed. SeverancePayCalculator.com.
You're going to get those who use it or listen to us this morning on the radio show say, whoa, I got a friend, I got an Uncle Bob who says it's a week per year or 2 weeks per year. This does not jive with your Severance Pay Calculator.
Everyone has an Uncle Bob or an Aunt Mary, and they seem to know a bit about employment law. And as good intention as these folks may be, John, the reality is those misconceptions, those beliefs are wrong, okay? That's why we're here, because so many people, I've seen hundreds and hundreds of people accept pennies on the dollar and then, go back and realize they can't do anything about it. So it is accurate. It is completely accurate. SeverancePayCalculator.com.
We'll take a short break. Emails, it is help@employmenthour.com. The phone number, 1-855-821-5900. Anytime you want to get a hold of Lior or a member of his team. Lots more of Employment Hour in 30 coming up. Lost your job? Find out how much severance you're owed right now. SeverancePayCalculator.com. Accurate, anonymous, and free. SeverancePayCalculator.com. Lost your job? Employment law myth number 5.
There's no point in calling a lawyer because my employer treated me fairly.
Fact. Over 90% of people are offered much less than they are owed. Always go to employmentlawyer.ca and check with the employment lawyer first. And more Employment Hour in 30. The number to call anytime, 1-855-821-5900. It is help@employmenthour.com as well through email. We'll get to a call from Kelly. Kelly calls in at that number. We'll see what he has to say.
Been working for a company for about 11 years, driving truck locally, and recently they want us to sign a letter stating that we'll work up to 60 hours, and I don't want to. They're telling me it's kind of the company policy and the standard, and I'm saying I don't have to work more than 48. My HR department called me, basically saying, this is company standard. She sought legal counsel, and she's within her rights. What can they do to me?
That's a big change.
Well, it's a huge change, John. So the real question here is not whether working 60 hours is something that the Ministry of Transportation allows. The question is, does that amount to a change in the term of Kelly's employment? Now, if I understand Kelly's question, Kelly's worked 48 hours, and now the company says, we want you to work 60 hours. Well, that's a huge change, another 12 hours a week, absolutely. And because it's such a big change, John, they don't have a right to do it. Irrespective of what the limits are under the Ministry of Transportation, they can't change terms of employment that way. If the deal was from the beginning that he's going to work 60 hours, fine. But if initially the deal was 48 hours, now we want to make it 60 hours, they can't do that, which means Kelly has an option. He can decide to accept the change and start working 60 hours a week, or he can say no, and if the company does it anyway, he could treat that as a constructive dismissal and get his full severance. And I want our viewers to understand that you may often see, or you may sometimes see, an employer trying to change terms of employment. Maybe they'll change the hours of work. Maybe they'll change your compensation. Maybe they'll demote you or work location. If that happens, if it's a significant change, you don't have to accept it. You do have a choice. And that choice is to treat that as a constructive dismissal. Now, it's not every change, John, that results in a constructive dismissal. It does have to be a significant change. But listen, in Kelly's situation, going from 48 hours to 60 hours, that's a very big deal. And if any of our viewers are in that situation, you have to get advice. Don't quit first. Call me first, because we can pursue this as a constructive dismissal and make sure that you go to a place that doesn't change the terms of your employment while still getting severance.
Again, that number, 1-855-821-5900 to get a hold of Lior or the rest of his team. You know, a term that gets thrown around the workplace and the working world all the time is independent contractor versus employee. So what is the difference, first of all?
John, an independent contractor is a very different beast than an employee. And so many times, every single day, John, multiple times a day, I speak with people that believe that they're independent contractors, or I speak with companies that believe that they employ independent contractors, and they're not really independent contractors. So let's start off with the idea that an independent contractor, John, is someone that's in business for himself or herself, someone that tries to get customers, someone that manages their expenses in the hope of making a profit, someone that doesn't have regular hours, doesn't work exclusively for a company, someone that really is a business person. Now let's compare that to an employee. An employee has a company or an employer that they work for. They would have hours fixed by the company. They would be working, doing the company's work under the company's direction. They're not self-employed. They're not independent contractors. So the real question is, are you really self-employed, or do you work for someone else? What you call yourself, what someone else calls you, is irrelevant and doesn't even factor into the analysis.
Does it really matter? Is one better than the other to either be an independent contractor or an employee?
Well, it's a huge deal, and it absolutely matters, because if you're an employee, that means you have the rights, the entitlements, the protections of an employee. So you have rights with respect to minimum wage and hours of work and overtime and vacation and severance, etc., etc., etc. Whereas an independent contractor doesn't have any of those rights. So you really want to understand what you are. And where I see this issue distinguishing between contractors and employees come up all the time is when the relationship comes to an end. When the person is being terminated, at that point the company may say or believe that they were an independent contractor, not pay any severance. But if the law considers you to be an employee, then guess what? You're an employee and you're owed severance, and it could be the difference between getting zero severance to getting $100,000 in severance. So it's a huge deal to understand what you really are, and what you call yourself, as I said, does not matter.
Can you still be an independent contractor if you don't fit, say, all the criteria, or if it's a handshake agreement between you and someone else? Does it still work?
So what we try to do, John, is there's a number of criteria, but what we try to do is look at the relationship as a whole. So it's not enough to say I meet one criteria on this end and another criteria on the other end. We look at the relationship as a whole and see, are you really self-employed? Are you a self-employed business person, or you work for someone else? You know, there's an example I like to use, and that is the plumber example. So if you call a plumber to your house to fix a leaky sink, then that plumber comes to your house, fixes the sink, and then moves on to their next job. And they have another job, and hopefully they have more jobs tomorrow. They don't work for you. They're an independent contractor. They came to you, they did a job, you paid them for that job, and they move on. Now, if someone else comes into your house and does work every day, Monday to Friday, 9 to 5, well, at that point, that person is an employee. So what you have to ask yourself is, are you the plumber, or like the plumber, or are you something other than that? If you're something other than that, then you're probably an employee in the eyes of the law, which means, again, you have the rights, the protections of any employee.
Someone could be listening to us or watching this saying, oh, wait, I sound like an employee, but they don't deduct taxes from me. Does that make me an independent contractor?
It does not matter, John. Just because the company doesn't deduct taxes doesn't mean you're an independent contractor. I had a lady contact me recently. She was working for a company as a bookkeeper for over 20 years, Monday to Friday, regular hours, and when she was let go, she was paid no severance. And I asked her, why wouldn't they pay you severance? That's ridiculous. She said, well, because I was an independent contractor. I was invoicing them. They were not withholding taxes. Well, John, of course she was not an independent contractor. She was an employee. She had a job. She went to work Monday to Friday. She worked from the company's offices. She was not an independent contractor. She was an employee. And because of that, not only was she owed severance, she was owed about 18 months pay. 18 months. So for her, John, that was about $65,000 that she was owed in severance. That's why it's so important to understand what you really are. It really could mean tens of thousands of dollars, if not more.
What if I'm incorporated, or I go and become incorporated? It sounds very important, but does it make a difference?
It's actually very easy to become incorporated. You fill out some forms, you pay a fee, and voila, instead of John, you're now John Inc. Yeah. The fact that you fill out those forms and pay the fee doesn't change the reality of what you are. It doesn't change the fact that you're still an employee. Anyone can incorporate, and if it was as simple as just incorporating, everyone can be an independent contractor. Every person that works anywhere could become an independent contractor just by filling out some forms. Well, the law is smarter than that, John, and because of that, we really have to look at substance over form. If you look like an employee and act like an employee, you're an employee. It doesn't matter what the other things suggest. Substance over form, that's always the lesson.
Before we wrap here in a couple of minutes, Lior, I want to talk again because it's so important. And just to reiterate, severancepaycalculator.com. Great tool.
It's a great tool. It's the first of its kind. It's the, when I first came up with it, some lawyers were very upset with me because I was essentially giving it away for free.
Right.
I was telling people, giving people access to that information so they can get it any time, whereas some people wanted to charge for it. But I believe in access to information. I believe in people having knowledge. So that's why the severance calculator is so important. That's why the severance calculator is a tool that's been used tens of thousands of times over the past few years. And I encourage all our viewers to go to severancepaycalculator.com. Even if you haven't lost your job, you should be armed with that information in case that unfortunate day ever comes when you lose your job. At least then you would know. And be a good friend, be a good family member. If you know someone that lost their job, don't just let them accept severance offers that are inadequate, just like 90% of people do. Severancepaycalculator.com or call me, of course.
And it's free and it's absolutely easy to use.
No strings attached, John. Not trying to do anything other than give people that information. You go there, you answer 3 questions. It takes seconds. My daughter did it the other day. She found out how much severance I owe her. That's a scary amount. But it is completely easy to use, so there's no excuse not to do it, John.
Done for another week. The number is 1-855-821-5900. It is help@employmenthour.com through email. employmenthourtv.ca rather is the website, so contact Lior and his firm anytime. And we'll catch you next Saturday morning at 10 here, right here, Employment Hour in 30.
Now we have to talk for 10.
captioning of this program is brought to you in part by SeverancePayCalculator.com. Find out how much you are owed right now. SeverancePayCalculator.com.